Okay, we're back on the record. This is Michaud versus Casey, 2004 DR 19706. It is my understanding that this is a continuation of the motion hearing that we began July 6th. Is that correct?
Yes.
And that was on the respondent's second amended motion for contempt enforcement and clarification. Correct?
Yes.
And if I can read my notes, I reviewed them. Mr. Michaud testified, and had he concluded his testimony?
Yes.
And where were we? Revisitation. Still on your motion? On your presentation?
I believe technically.
I guess the question is, do you have any further witnesses you want to call in?
I would like to call Miss Casey, sorry. What's her last name? Miss Casey.
Usually that just happens on Monday.
Right? Today is my Monday, Judge. I drove back last night from Nashville, so.
That's why the accent, Nashville. Okay, ma'am, if you come over here to the witness stand, I'll swear you in once you get there. Raise your right hand. You swear or affirm testimony you gave will be the truth, and nothing but the truth, so help you God? Have a seat there. And you may proceed.
Thank you. Miss Casey, do you recall, let me start over. I'm not even going to go into details with you. Can you tell me, since the last hearing, well, not July's hearing, but the December hearing that we had in 2015, since that hearing, have you had difficulty making contact with your daughter?
Yes, ma'am.
Tell me how.
My phone call attempts to her always go to voicemail, and I end up having to text my ex saying, hey, we're trying to get in touch with her. I've been given excuses that she's busy, she's running late, she's having dessert, she's playing a game. You know, it would be nice if you would put her sports ahead of that and be patient, never a forewarning. And I have another daughter who is 9 who does look forward to speaking with her sister as well. I was told at the December 21st, 2015 hearing that
If you'll ask some clarifying questions, I don't know if it's going to be hearsay or not.
I have a feeling that would have been something. Okay, so let's keep talking about the context. So you mentioned that when you call, it goes to voicemail, that you get excuses why calls can't happen at certain times. Have you ultimately gotten all of your calls?
at some point after delays, yes.
Okay. And give me your general feeling. Do you feel like you're constantly having to make the concessions?
Objection, roll.
Overruled.
Absolutely. I'm being told that Riley's extracurricular, or she's not available, so I have to be patient. There's nothing I can do, but I'm at the mercy of Tim to let Riley have that call.
Okay. Tell me about setting up your visitations. Has that been easygoing?
I'd object. It's the relevance and materiality. There's one issue raised concerning one supervised visitation in the motion that was filed. We're not put on notice of any other complaint by the former wife concerning any other supervised visitation. There was no amended motion filed after our last visit in court to deal with anything that she's had problems, or alleged she's had problems since then.
I agree, since the last hearing is not up for discussion today. However, Mr. Michaud spoke regarding March visitation, April visitation, May visitation. So my question was related to that. I can clarify further if that would help the court.
And I objected at that time to the relevance and materiality of those questions because it wasn't framed by the motion. I'm just asking that they stick to their motion. That's what we're on.
Well, let me ask a question, I guess. I have the motion from me, looking at it again. So, I guess, Ms. Jacobs, if you'll help me out, I'm looking at your motion. It talks about FaceTime and all the other stuff. But the actual missed visitation is in what paragraph?
6 is as close as it comes.
Paragraph 6. Which makes reference to April 16 and April 17 visitation, right?
The motion specifically refers to in 3G refers to their contact regarding setting up visitation for March. And
So March 26th,
and paragraph 6,
which is concerning April 16,
correct,
a contact on March 8 concerning April 16 and 17.
right. So those two, 3G and 6, refer to their discussions regarding setting up time sharing.
Okay, visitations that did not occur or communications concerning visitations on dates other than March 26, April 16, April 17, how would they be relevant?
I'm sorry? I didn't understand the
The
question.
objection was you were asking about, in a more general fashion, visitation problems over a multi-month period of time. He objected based on relevance. I then wanted to look at the motion, and the motion seems to pinpoint 3 dates.
Correct.
March 26, April 16, April 17. So as a follow-up to his objection, why would actual visitation issues or missed visitations on other dates be relevant?
The only other date that I would say is relevant would be regarding the May visitation. Your Honor overruled an objection made during the first half of this hearing. And Your Honor specifically stated that you would not consider it as a violation of the order, but that you would consider it with regards to enforcement and clarification.
All right, I think I'll overrule the objection if you limit it to that kind of scope. Just a general overall is too broad, so objection overruled with that clarification.
So with regards to setting up March, April, and May visitation, how have you gone about doing that?
Because I have a supervisor that has to supervise me, Deborah Hodges, I must include her in decision-making for what is a good date for everyone, not just Tim and me, but Deborah, because Deborah has her own family as well. So what the protocol is that when we have visitation, I ask Deb, what is some good dates, and look at my calendar, offer them out to Tim, and there are days that go by without a word, no confirmation, no nothing. And for our family, it involves not just driving 10 minutes, it involves 6 hours one way. My current husband taking time to get off work early to make those travels, a place to stay, confirmation. There's just many facets that are involved. So I'm on eggshells wondering, when am I going to get any response on a confirmation? And again, because the order, I'm at the mercy of Tim to respond to me.
Okay. So, actually, before I move on with the questioning, Your Honor, I'm sorry to go off topic. I see some people in the courtroom that I don't recognize. If there are witnesses here, I would invoke the rule at this time. I'm
I don't have any witnesses here other than my client.
sorry. Okay, then I'll.
Okay.
Sorry. So after you contact Deb and you find out her availability, you then contact
Yeah.
Tim.
I do a three-way text between Deb, Tim, and I.
Okay. And let's talk about scheduling for March visitation. Did you confirm dates with your supervisor, Deb, for March visitation?
Yes.
And what were those dates?
I have to go look at those documents again. I
The
apologize.
specific dates don't really matter.
Okay.
Did you send that three-way text message to Deb and Tim?
Yep. Yes.
Okay. And did you receive a response from anybody?
From Deb, yes.
Did you ultimately get a response at any time from Mr. Michaud regarding March visitation?
In refreshing my recollection, can I see that?
I will show you documents to refresh your recollection.
Thank you.
May I approach the witness?
Yes.
I have no objection to knowing evidence to be referred to the evidence.
I just wanted to refresh your recollection.
May I have the mark, Judge, since you're using the document for reference.
Two different ones.
There's several documents.
Well, all right. Labels, you tell me how many you have, please.
Sure.
I'll just,
Are those 1 and 2 from
these are 1 and 2 from my 4.
5? But I think they're all composite.
Well, that's a question. You want to put it as a composite?
I have no objection to that.
Okay, it'll be composite 3. We have the package for section. There you go.
Showing you what's been marked as respondent's composite exhibit 3 for identification.
Yeah, I never received a response from Tip. It was just truly a conversation between Deb and I in the beginning about the confirmation for March's visit.
Did you ultimately receive an email from Mr. Michaud regarding your daughter having a track meet
Yeah.
on that weekend that you had chosen?
Yes.
Objection to the witness testifying about a document that's not in evidence. I don't know whether it's included in this email trail back and forth. She's asking.
It would be hearsay if it's not in that packet.
If the statements are from a party opponent, I would
I
argue
need to
that's
have
an
a written
exception.
document. She's telling me what the written document shows, so I'd have to have a written text.
Did you, ultimately, do you recall whether you had your 12 hours of time sharing in March with your daughter?
I did not.
Tell me why.
Due to the fact that Tim decided to take it upon his own will and sign her up at the last minute and taking her across to Tampa for this. She did not get back until 5:30 at night, and per the court order, I get 6 hours Saturday, 6 hours Sunday. And I had given the 30 days notice as I'm supposed to in this order. And at one point, Tim inquired if I should.
And again, I would object to her testifying about a document not in evidence unless this is some verbal conversation.
Sustained, if you'll clarify your question, please.
Actually asked a question that Elizabeth, okay. So you were supposed to have 6 hours Saturday and 6 hours Sunday, but your daughter didn't come back to town until around 5:30, so.
Yes, and what happened was, is Deb
Hold
was.
on, let me ask you a question.
Sorry.
At that point, was there any discussion between you and Mr. Michaud regarding how you would see your daughter?
Yes, the three-way text between Tim, Deborah, and I was that I was going to relinquish Deb for the day since she should not be on hold all day since she does have a family. And it was agreed with Deb as well that she had family to take care of in that evening and couldn't do a visit from 6 till 10 o'clock at night or 6 to 11 or 6 to midnight. It was just not feasible for her.
Okay. So was there a discussion as to when you would get to see your daughter Riley?
I was just told that I would choose to get her, because I chose to not see her on Saturday, that I would get Sunday.
So how much time did you get to spend with your daughter on Sunday?
I want to say, I think maybe 9 to 4. I cannot state specifically, but I was not given my full 12 hours.
Okay. In March, did you contact Mr. Michaud regarding time sharing in April?
Yes.
And do you recall what dates you chose?
See my text messages.
Possibly. I'm gonna rephrase my question for you. Actually, I'm just gonna strike it. Did you have any visitation in May?
No.
Can you tell us why?
Because I had originally given the 30-day notice, and I inadvertently double booked myself. A very good friend of mine was graduating with her PhD, and I had offered our home up. And I was still within the 30-day mark, and I asked if it could be removed. I confirmed this with Deb as well, because again, she comes into factor. and she was in agreement that she was available for the other 2 dates that I was offering out.
And going to show you these markers.
Are you seeking to introduce into evidence?
I will be, yes.
Is there any objection?
I have the same objection that this is not contained within the motion, Judge. I understand you've already ruled.
In the same ruling, I'm not going to consider it for its own independent violation, but it may be relevant to the others alleged. It'll be admitted as fourth.
I'm going to show you what has been marked as Respondents Exhibit 4. Can you tell me what that is?
The 3-way text between Tim, myself, and Deborah Hodges.
And is that the text message where you asked to move your May visitation date?
Yes, ma'am.
And what response, if any, did you get?
Sorry, cannot.
After that, did you ever receive any other options regarding when you could do your visitation?
Nope, I was denied anything other than the date I had earlier requested.
Let's talk about your FaceTiming with your daughter. When was the last time you had Skype or FaceTime contact with Riley?
August 2015?
And you heard at the last hearing a discussion about a prior order denying your request to reinstate the FaceTime. Is that correct?
That's correct.
To your knowledge, is that order still in place?
Your Honor, object that calls for review with court to determine whether that order remains in place.
Sustained.
Have you attempted to have FaceTime and or Skype contact with your daughter since December of 2015?
Yes.
Has it ever been permitted?
No.
Do you feel that Mr. Michaud is encouraging a relationship between Riley and you?
Objection, relevance.
Sustained. Facts to go behind that might be relevant, but for opinion would not be helpful to me.
I have no further questions for this witness.
Cross-examination?
Ms. Casey, you know that your daughter is involved in soccer and in track. Is that a fair statement?
Yes.
You have received from Mr. Rashad schedules of when she participates in those events. Is that also fair?
Yes.
Do you attend any of those events?
Because where I live, I cannot.
During the occasion when Riley was running track in Tampa during this March visit, March 26th, did you try to attend that event since you would be in Florida anyway?
Tack on another 3 hours. place. That was impossible for our family.
The answer to my question is no.
No.
You got a text, and it's in that package of materials that we marked as exhibit number 3, from Mr. Michaud in the early afternoon, it was before 3, advising you at that time that he was heading home, correct?
Yes.
And you sent a text back after that saying, you're going to be here too late, I don't want to see Riley today. Is that fair?
I don't believe that was said.
Tim, due to the current time of the day, the fact you've not left Tampa to drive home, and Riley not finishing, including Deb being in a whole pattern, it would be best to just have our visit at 9 to 5 tomorrow. That's your text to my client, correct?
Correct.
You know very well, let me ask you this. You have read the motion that was filed on your behalf by your lawyer. Is that a fair statement?
Yes.
Would you like to see it again? Does that help you?
Sure.
Let me show it to you. I have the page tab for you. Your attorney was kind enough to quote directly from the June 19, 2013 amended supplemental final judgment in the parenting plan that it incorporated. In paragraph 2B. You see that?
Yes, sir.
You're aware from past experiences here in the court that the amended supplemental final judgment entered on June 19th, 2013, and the parenting plan it incorporates uses the language, the mother shall have telephone and/or Skype communication with the minor child. Correct?
Yes.
And you have known that that has been the order that has been in place since that time, correct?
Yes.
Your motion didn't cite any other order that amended those specific language concerning telephone and/or Skype, correct? And as counsel just mentioned a few minutes ago, your lawyer at that time, Harley Gooten, had filed an Ore tennis motion, that resulted in an order on August 10th of 2015 that specifically denied face or Skype time, correct?
Yes.
Despite those orders being in place, you're the proponent of a motion trying to find my client in contempt when the court has already said that he does not have to provide FaceTime or Skype.
That's not true.
Let's go through your motion. Your motion in paragraph 3, starting with subparagraph A, talks about your attempt to speak with Riley on December 21st, 2015. And at the end of that paragraph, you indicate that you ultimately spoke with Riley at 7:28 for 6 minutes, correct?
Via the phone, yes.
Right.
Couldn't hear?
Via the phone.
Thank you.
So you had telephone contact on that day.
It's much different than Skype.
The answer to my question is yes, I had telephone contact on
Yes.
that. Paragraph B, you have an issue concerning December 23rd, 2015, and you indicate in your own motion, ultimately Riley called mother at 7:02 for 2 minutes. So again, you had telephone contact with her on that day, correct?
Limited.
Is my client limiting the conversation, or are you and Riley limiting the conversation?
How would I limit my daughter's conversation?
Perhaps by what you're speaking with her about?
How would you know what I talked to my daughter about?
No.
Exactly, so why is there assumption?
So is there anything in your motion to suggest that Mr. Michaud in any way limited the conversation to 2 minutes?
Considering the situation, she's a teenager and has her dad listening to every conversation. I
You-
guess you're the expert right now, you're telling me.
You didn't put that in your motion, though, that he was
My
an attorney.
attorney is the one that made this motion.
Did you read the motion before it was filed?
I did.
Let's talk about the 24th. You indicated that you didn't have FaceTime contact. Did you speak with daughter on the phone that day?
I don't believe I did.
The subparagraph D says the child called you at 5:36 PM for 4 minutes. Does that refresh your memory?
Sure, she called me. Yes, no Skype.
You talked Christmas Day not having FaceTime. Did you speak with your daughter on Christmas Day?
After numerous attempts to FaceTime, yes.
Did you talk with her for 21 minutes on that day?
Yes.
December 28, 2015, you spoke with your daughter or not?
I'm sorry, could you ask that question again?
December 28, 2015, did you speak with your daughter?
Obviously, December 28th says no.
Did you ever call that day?
Of course, I don't miss a call.
We talked about the March visit. April, the difficulty with April was that you scheduled for a time that you were ultimately unavailable, is that correct?
Yes.
And the priority was you could come down here to see Riley, or the alternative was you were having a party at a house for your friend, correct?
It's an unfair statement, your question.
Was that what the conflict was, the
No,
party
the
at your house?
conflict was that his unwillingness to be flexible as I have in the past.
You had a specific date set, and it was your schedule that made that first date unavailable, is that correct?
Yes, but I was in my 30 days request.
The last time that you had Skype or FaceTime with your daughter, did you hold up a sign that says, "I will get you home"?
No.
Take a minute to step down, or you want to keep going? Sorry, what'd you say?
I said I didn't.
Okay.
I'm just waiting for the witness.
Just go forward.
Go ahead. Go ahead. Sure.
Ms. Casey, I wouldn't ask this question, but for your lawyer asking my client, you were here the weekend before Father's Day, is that correct?
I don't remember, I'm sorry.
Did you ever ask your daughter Riley to make or send a Father's Day card to her father?
We've talked about yes.
Did you help her buy one or make one?
She said she already did.
I've asked you this question before, so let me just ask it again the same way I asked it before. Do you acknowledge that it's your behaviors that have caused your limited supervised visitation with your child?
Objection relevance.
Overall subject being tied together, I can see potential relevance to current actions by the parties. You can answer that.
Fields res judicata, that we've relived this over and over again, and people graduate. I've never graduated. I've been on court-ordered therapy. I've presented my
Can
therapy.
you instruct the witness to answer my question? This is a yes or a no.
Your attorney, if your attorney wants to, you to explain your answer, she'll make notes and she'll bring that out in a minute. So if you could just answer the question. I think the question was, do you believe that any actions by you cause you to have limited contact with your child?
The order states I did.
I wasn't asking what the order said, I asked you what you thought.
The order says what it is.
I would again ask the board to instruct the witness to answer the question.
I think she did in her way. Objection overruled.
I don't have any other questions.
Is there any redirect?
Very briefly.
Okay.
To your knowledge, do you have any affirmative duty to ensure that your child has written communication with her father?
No.
You were asked whether you believe that you have any responsibility for your limited contact. Do you want to explain why you feel the limited contact is as it is? Or what role you may have had in it?
There was lots of assumptions. Lots of people that were unable to testify, not by choice. An order that was written that extricated me out of my daughter's life. No graduation. Promise. No reunification. And at this time, my relationship with my daughter, I only physically see her 12 hours a month. My Skype, my FaceTime was my ability to see my daughter during the month. I have followed the rules of this order. I miss my daughter so much. I miss the ability to see her. I just want a relationship with my daughter. And the ability for my other daughter to have a relationship with her sister. I don't want to be a frequent flyer in this courtroom. I just want a relationship, as limited as it may be. I just miss her.
I have no further questions.
Any other questions?
I do. You say that there's no graduation of your situation. You're aware that under the parenting plan, there were terms and conditions for your time spent, is that correct?
Yes.
And paragraph Roman numeral 6, subpart 1, A through E, set forth all of the things that you were supposed to do in order to continue having any contact with your daughter, correct?
It's illegal.
I'm not asking you what your opinion was of the order. You were aware that there were conditions put on you that you were supposed to perform.
Conditions that could never be met.
Have you provided the therapeutic records to the court that acknowledge in your therapy that you've accepted your inappropriate actions in filing false abuse charges against the father and that the father has not abused the minor child?
It's illegal.
Have you done that?
No, it's illegal.
Have you filed any therapeutic reports with the court at all in the last 12 months?
Yes.
When's the last time you did so?
Actually, they're in that binder right there with dates on them.
When's the last time you did so?
Last August,
So over a year ago.
in the year.
Did you file any therapeutic reports in 2016?
No, all the therapeutic reports said there is no problems with me whatsoever.
The last time you filed any therapeutic reports with the court would have been sometime in August of 2015.
Correct.
Are you still going through therapy?
Yes, sir.
Why haven't you filed any therapeutic reports in your therapy in the last year?
Because I met the criteria by filing the documentation.
I don't have any other questions.
Questions?
No.
Thank you, ma'am. You may return to seat. Appreciate it. All right, further evidence?
Nothing further, Your Honor.
And do you all have evidence that you'd like to present?
I'm trying to recall what we testified to the last time, so I don't repeat myself. I think we need to address the 3 visits that have been addressed today, so I would recall my client.
Please come over here. I'll swear you back in, sir, once you get there. Right. You swear affirm testimony you give will be the truth, nothing but the truth, so help you God.
Yes, sir.
Have a seat.
Mr. Michaud, let's talk about these in chronological order. The March supervised visitation, what happened?
We agreed that Riley would participate in the track meet in Tampa. I'm sorry, Amy and I and Deb Hodges also agreed that she would take a later than normal time period. First time to a track meet of this caliber, had no idea how long it would run. It lasted much longer than I thought it would. I communicated with Amy throughout the day, telling her when she was running, her next event was up. I communicated when I was leaving. She apparently had already communicated with Deb and canceled the visitation.
Don't tell us what's apparent. Okay, just tell us what your communication was.
I got a text saying I am ending the visitation for tonight because it would pretty much be a waste of time.
Look at exhibit number 3 and tell me when you told, according to those text messages, when you told your former wife you were heading back from him.
3:22 p.m.
And the response that you got was that she was canceling that visitation.
Yes, that would be correct.
April, I think, is the next in the chronology of issues that your former wife was raised. What happened with the April supervised visitation?
She had her visitation.
Was there any problem with the visitation that happened in April?
There was originally soccer games scheduled. Amy asked for those dates. My response was, I just don't want her to miss the games. In the end, the games got rescheduled. Amy had her visitation.
All 12 hours?
Yeah.
May, tell us what happened in May.
May, I got an email requesting May 21st and 22nd. I agreed to it. Some short time later, I get an email or some correspondence back from Amy stating the fact that she cannot do that. I asked her specifically what the issue was. She responded that her friend was graduating and that she needed to do that instead. And then she requested another day.
Objection, hearsay.
What was the conflict with the second set of days that she requested?
Riley was going to be running in the middle school state championship. I thought that was important.
Did you communicate that to your former wife?
I did.
I don't have any other questions.
Ross?
When Ms. Casey contacted you regarding changing the May dates, the dates that she was asking for, were those still more than 30 days out?
I don't know the date that she requested.
May I approach her?
Of course.
Showing you what's been marked as Respondents Exhibit 4.
Yes, it was more than 30 days.
And at that time, the date she was requesting, you had not actually scheduled or enrolled Riley in the track meet yet, is that right?
Yeah, I physically could not.
And does your time-sharing agreement, or I'm sorry, time-sharing schedule specifically set forth the times and days that Ms. Casey has time-sharing on her weekends?
I don't believe so. I think it's 6 hours a day is what it states.
Okay. And so, when you got home at 5:30 with Riley from the track meet in March, how did you propose that Ms. Casey would have 6 hours that day with Riley?
Well, I didn't. I mean, I expected her to have a little less and then make it up on Sunday like we've done in the past.
So you expected Miss Casey to be flexible?
For her daughter? Yeah, I would think so.
Okay.
Would make sense.
Are you flexible in arranging things for your daughter to have contact with her mother?
She got 8 hours the next day, so I would have to say, yes, I have been flexible.
Did you have any discussion, I don't want to know what the discussions were, but did you have any discussions with Deb, the supervisor, regarding her ability to remain that late on a Saturday?
On that specific Saturday?
Yes.
I think I did because we were already scheduled not to come back until 2, so she'd have been there from 2 to 10 anyways. So 6 to 10 would still be 4 hours, plus the 8 on Sunday would still give her 12. She wasn't gonna stay longer, she was just gonna not be there as early. So you still would've gotten 12 hours.
I have no further questions.
Nothing further.
You may return to seat, thank you, sir. Mr. Peters, further evidence?
No, Your Honor.
Ms. Jacobs, any further evidence?
Nothing further, Your Honor.
Okay, let me find a couple things in the court file before we go to closing. The order, Mr. Peters, that you were referring to concerning a change to Skype contact, when was that entered?
There were two, Judge. There was an August order that denied the reinstatement. And then there was at the December 21st hearing, the judge said, go back to following the supplemental final judgment. She reinstated all of the supplemental final judgment.
Okay, so the Skype and/or telephone was reinstated?
We believe so.
Was your argument?
August 10th of 2015 was the date the order was entered. I have copies of the order.
Well, it's easier. And then the parenting plan, when was that set? I haven't
June of 2013.
found the final judgment, but I didn't find the parenting plan.
It's Exhibit C to the supplemental final judgment that was entered on June 19th. I have copies of those for the court too, if you wish.
Copies of the,
Both. The amended final judgment and the parenting plan that was attached to Exhibit
if
C.
you have them, yes.
You will.
A second, please.
Okay.
So Ms. Jacobs, closing.
Your Honor, we are here today and back in July on our motion for contempt enforcement and clarification. And the reason we included all three is because we agree and acknowledge that for the most part, Mr. Michaud walks a very fine line ensuring that he doesn't actually violate the letter of the order, only the spirit. And the spirit of the order, and I would argue also the letter of the order, is that Mr. Michaud is supposed to encourage a relationship between the child and her mother, and he doesn't do that. Yes, he allows them to have their 3 phone calls a week. Yes, although even that, he has testified that those phone calls often get changed, sometimes at a moment's notice. And that it's constantly Ms. Casey that has to work around Mr. Michaud's schedule. He will contact her at the last minute and say, I'm taking Riley to the movies, so you can't have your phone call unless you're available right now. And Ms. Casey will drop everything and have her phone call right then. But part of our request today is for not only enforcement, but also for clarification. And the clarification that we're seeking is prioritizing the things that are important in this child's life. Does a movie come before contact with her mother? Does all of her sporting events come before contact with her mother? Mr. Michaud testified that in the month of, I believe it was April, she had a sporting event every single weekend. And when Ms. Casey picked the weekends, Mr. Michaud said she's not missing her game. Now, ultimately, that game got rescheduled, and so there was no issue. But the belief at the time that this visitation was scheduled was that, just like in March, if the child has a sporting event, that sporting event is more important than the very few hours that she gets to spend with her mother. And we're asking the court to clarify for the parties today whether that's actually the case, whether time with her mother comes before extracurricular activities and movie dates and dessert and whatever other